morning. Court will call on the record State of Wisconsin versus Stephen Merkel, 25 CF 57. Appearances, please.
Zeke Wiedenfeld appears for the state.
And Attorney Tyler Yachman and Attorney Obi Azulu appearing on behalf of Stephen Merkel. Mr. Merkel also appears in person in custody. Good morning.
Good morning. This matter is on today for sentencing hearing. First of all, is the state in compliance with victim rights?
Yes, the state is in compliance with victims' rights. I appreciate the court giving us some extra time to make sure that family could be here. There's victim impact statements that are on file. I know there is a grandmother who's still on the way, but she was quite a bit out, so the plan is we're going to start and we'll see when she gets here. But I'm not asking to delay the proceedings any further than we have already.
All right. I'll turn to the defense then. First of all, I do note that the defendant pled guilty to first-degree reckless homicide of a child whose initials are MM by the use of a dangerous weapon and showing utter disregard for human life. This was contrary to section 940.02 sub 1 and the dangerous weapon enhancer, which is 939.63 sub 1b of the statutes. This crime is a Class B felony with the penalty enhancer. It's punishable by a term of imprisonment not to exceed 65 years. The first matter that I want to address is when I was reviewing this matter in preparation for the sentencing today, I was reviewing the plea hearing, which was several months ago. At the time of the plea hearing, the guilty plea questionnaire was submitted to the court with a number of attachments, including the two jury instructions that apply here, which are jury instruction 1020 and jury instruction 990. 990 specifically is the instruction that talks about the jury being asked the question if they find him guilty of the substantive crime. They are then asked the question about whether the defendant either possessed or used a dangerous weapon in the commission of the crime. I know that both of these jury instructions were included as attachments to the plea questionnaire. I recall that. I recall talking with the defendant about those jury instructions because they contain the elements. I recall reviewing that with the defendant. I recall that both of those documents had his signature on them as well because he had reviewed those with his attorney, who at the time was Attorney Josh Ryan. Somewhere between the plea hearing and those documents being scanned and uploaded to the electronic file, jury instruction 990 must have been misplaced or misfiled or something because it is not showing in the electronic record here. The guilty plea questionnaire is filed, jury instruction 1020 is filed, 990 is not there. So when I recognized that yesterday, I asked my clerk to send an email to the attorneys alerting them to that fact and asking the defense if the instruction 990 that I recall going through with the defendant that he had signed, if for some reason it was still contained in their file. Mr. Yachman, you replied to my clerk that it was not in your file, correct?
Correct.
The only thing I can surmise then is, as I said, somewhere between being on the bench with me for that plea hearing and being taken to the clerk's office to be scanned and uploaded to the file, it got misplaced. Things happen, mistakes happen. I'm not concerned about it in terms of I know I went through it, I know it was with me at the time of the guilty plea questionnaire and that the defendant acknowledged he had reviewed it with his counsel. But for record-keeping purposes, I did want to make a record of it and confirm with Mr. Merkel that he recalls that as well. I think it was either late yesterday or this morning, Mr. Yachman, you actually uploaded another copy of JI 990 to the file. Is that correct?
That is correct, Your Honor. Yesterday I had my staff go with Mr. Merkel and ask if he recalled reviewing that instruction with the court as well as with Attorney Ryan. He said that he did, and he did sign an additional copy just to help make that record clear.
All right. So, Mr. Merkel, do you understand everything that I've stated here so far?
Yes, Your Honor.
Do you understand what I believe happened in terms of just the paperwork for the jury instructions which contain the elements for this crime and the penalty enhancer?
Yes.
And my guessing as to what happened to one of those documents?
Yes.
Do you have any objection to the court proceeding with your sentencing today?
No.
I just want to confirm then that in terms of the elements of the crime, jury instruction 1020, which contains the elements of first-degree reckless homicide, you did review those elements with your attorney, Mr. Ryan, back at the time of the plea?
Yes.
And do you recall that those elements are that you caused the death of M.M., that cause means your act was a substantial factor in producing the death? You remember that that is the first element?
Yes, Your Honor.
The second element is that you caused the death by criminally reckless conduct, meaning that your conduct created a risk of death or great bodily harm to another person, that that risk was unreasonable and substantial, and that you were aware that your conduct created that unreasonable and substantial risk of death or great bodily harm. That's the second element. You recall discussing that with your attorney as well?
Yes.
The third element is that the circumstances of your conduct showed utter disregard for human life. Do you recall discussing that with your attorney as well?
Yes.
That's from instruction 1020. Instruction 990 is with regard to using or possessing a dangerous weapon, the penalty enhancer here. Do you recall reviewing this instruction with your attorney?
Yes.
And what would have to be shown here if you had had a trial, if they found you guilty of the first-degree reckless homicide, they would then, meaning the jury, have to answer the question, did the defendant commit the crime of first-degree reckless homicide while using or possessing a dangerous weapon? Dangerous weapon being defined to include any firearm, whether loaded or unloaded, and that they had to be satisfied beyond a reasonable doubt that you had possessed or used that dangerous weapon while committing the crime. To answer that question, yes. Do you remember reviewing this instruction with your lawyer as well?
Yes.
And do you remember discussing this with me at the plea hearing?
Yes.
Do you recall signing both of those jury instructions at the time you reviewed them with your attorney?
I do.
Your lawyer has now filed with the court another copy of instruction 990 that you signed, it sounds like yesterday. Is that correct?
Yes.
Do you have any objection to the court proceeding then in this manner?
No, Your Honor.
All right, thank you. The next question I want to ask of the defense is, did you have a chance to review the pre-sentence evaluation that's on file?
Yes, Your Honor.
Do you have any additions or corrections that you believe need to be made to it at this time?
No, Your Honor.
I have also reviewed the victim impact statements, one from the victim's mother and one from his grandmother, one from his grandfather. The PSI also contains statements from the victim's mother and his father. And then I've also reviewed your sentencing memorandum, Mr. Yachman, that you filed on behalf of your client. Were there any other victim impact statements or materials that the court needed to review other than the file?
No, Your Honor.
And have you had a chance to review those victim impact statements?
Yes, and I've also had the chance to talk about them with my client as well.
All right. Are there any additions or corrections that you believe need to be made to your sentencing memorandum at this time?
Your Honor, I do believe I put the maximum penalty without the, when I did refer the maximum penalty, I did not include the enhancer. It would be 65 years instead of 60. Substantively, it doesn't change our argument at all, but I did, I think, note that I did forget to add the enhancer with that.
All right. You have discussed that with your counsel, or with your client, I should say?
Yes, Your Honor. That
Okay.
was brought to our attention yesterday as well.
Okay. I did see that as well. Is there anyone for Mr. Merkel that wishes to give a statement to the court today?
No, Your Honor.
And we'll get to that, ma'am. You're considered a victim in this matter, and I'll get to that in just a second. I'm just inquiring of the
She's-
defense.
She's his daughter, so I don't know who she wants to speak on behalf of.
Okay. Okay, you'll get that opportunity, absolutely. Okay, and besides his daughter, is there anyone else who wishes to give a statement on his behalf today?
No, Your Honor, and I guess just for the record, we would be happy if Mr. Merkel's daughter would like to speak on his behalf or as a part of the victim's family. I think either one would be appropriate.
Okay. I always have people that wish to give a statement to the court do so before either attorney makes an argument. So that's why I'm asking you now. You're not aware of anyone besides his daughter?
No.
Is there any reason then that I should not turn to the state at this time?
Only last thing I'd like to note, Your Honor, I did see that the jail custody credit form came through this morning, and I just would like to have that note for the record. We had no objections to what was on there.
He was taken into custody on the date of this offense, correct?
Correct.
And has remained in custody since.
Correct.
All right, so I'll turn to the state. I know you stated you're in compliance with victim rights. I know that Mr. Merkel's daughter wishes to give a statement. Is there anyone else who wishes to give a statement today?
Yes, I believe there's other family members of the victim.
Okay, so who would like to speak first?
We need to put you on microphone.
Yeah, and then you can start by saying your name, and then what you would like the court to know.
Good morning.
Good morning.
Can you state your name for the record?
Marissa Ann Merkel.
What would you like to say?
I would like to say that I wanted to speak on my father's character and on the person that he is, that I know him as, before all of this happened. I know this was a tragedy, and there's nothing that can bring my brother back. But I know that my father would never intentionally hurt my brother. I know that it was a very reckless decision, but he is not the monster that everybody is painting him to be. And I just want you guys to know that he is a good man and he is a good father. He loved MM very much. And this has torn me into two halves in ways I cannot explain for this court. But I wanted you to know who my father really is.
Thank you. Good morning.
Good morning.
You are Mikey's mother?
I'm Michael's mother, Melissa.
Melissa, can you state your name and spell it for the record?
Yes, Melissa Meagher, MEAGHER-MERKEL.
Melissa, can I ask you a question?
Yes.
I've been referring to your son as MM out of respect for his and your privacy. Would you like me to continue that, or would you like the court to use his name? It's up to you.
Yeah, yes, I would like to use his name, because in what I'm going to read to you, I use his name.
And do you use the name Michael or Mikey for him?
Well, both.
Both?
But a lot in my what I wrote, I'm just Michael. But yes, we all considered him Mikey. Is it okay to start?
Of course.
I would like to start out by saying who Michael Meagher was. Michael was a sweet boy who loved life, and he lived every minute of his life to the fullest. He played soccer, and he was very good at it. He was just beginning to be super interested in baseball, and he enjoyed playing catch with me, and I would throw the ball to him so he could bat it. And I also took him to the local batting cage to hit baseballs. And so then Michael had just received a special bat, a Rawling bat, neon green and black from Santa Claus. Michael had many other things he liked to do too. He was very busy. He liked bike riding. He liked riding, he had a gold scooter that he liked to ride, and he just got a mini bike from his dad that he liked riding. He loved swimming, fishing, golfing, rollerblading, playing video games, sledding. He actually sledded the week before he passed away. And creating art and listening to his favorite music, especially by Imagine Dragons. His favorite colors were blue and neon green. And he liked to collect Pokemon cards, Hot Wheel cars, and train set parts. And he and my dad, his grandpa, were going to put together a vintage train set together, and they were like going to the hobby stores and collecting all the parts for it. Michael was attending religious education classes and was going to make his first Holy Communion. And he was learning the Our Father prayer really well. Michael just lost a tooth the week before he passed away. And he was planning his birthday party, even though it was in June, because he went to like 5 birthday parties. He was very popular. I'm sorry, I lost my spot. He was very well liked by his classmates, and he had a lot of friends, so many friends. Michael's 1st and 2nd grade teachers loved him so much and said such nice things about him. As a teacher myself, I think that's really a very high quality, that he was so well loved. He was very smart, and he was good at math, and he enjoyed building things, and he would go to his dad's wood shop to make things out of wood, and he wanted to help his dad and do carpentry with him when he got older. Michael had a smile that would light up a room. His laugh and his voice are so very missed. And he had an awesome sense of humor. And he would do his happy dance, or he would make these silly faces that would just make us giggle and smile. Michael's my youngest child, and he is my baby. He has 2 older sisters, Marissa and Madeline. Both sisters are very sad. They missed their baby brother. They both had different bonds with him, different years apart. Halloween was very hard because they all loved dressing up together and celebrating together. It was just the beginning of this holiday season and how hard it's going to be without him. Michael lived life, like I said, every minute here to the fullest, and he had a good life with his family, his friends, and I. We were a happy family. He was a happy, healthy 8.5-year-old little boy. He had his whole life ahead of him. I know he would have did great things. I would always think about, like, what's he gonna be when he would grow up, and I would ask him things. I just know he would do great things, and he would make a difference in the world. Had he not been cut short of his journey on earth, and 8.5 years is far, far too short. Losing Michael has affected all of us. The loss of my child is hard to really describe in words. It's a pain, an ache. My heart is just broken. This is my baby, and I miss him constantly. I miss caring for him and doing all these things we did together. His shoes are still where he left them, his toys, his stuffed animals, his school backpack. I sleep with his stuffed animal in his blanket every night. The empty chair at the kitchen table is always there. Constant reminder that he's gone. It is so hard each day. As a mom, I'm expected to be so strong, but I try so hard to be strong for the girls. It's just so draining, emotionally and mentally draining. Some days it's just too, every day is too much. And I really don't know how I've made it this long without him. And I still can't believe that this actually happened. It's so weird. I still think he's gonna come through the door. I would do anything to protect Michael. I would walk through fire. I would throw myself in front of any danger. I used to have him call me just when he was like 2 blocks away, just to help cross him on the streets when he would ride his bike to his friends. So I would do anything to help save him and keep him safe. I never knew this tragedy would happen when I let him go with my mom to Wisconsin. Never expected it. It's been an absolute nightmare. At first, it was a total shock. And then just depression and sadness, still in anger. And many days I lay on the couch and I just couldn't even get up with Michael's dog. I was unable to even go back to work for a long time. And when I did, it was still depressing because I work with other children. And I think, why did my little boy have to be gone? When I'm this person who's taking care of these kids every day, all day, making sure they're safe. It's very hard. And I see the world differently, and I will never be the person I was because I feel like a part of me too died on January 20th. I just don't see anything the same anymore. I have wanted to say things to you, Steve. Why, oh my God, why? Why? Why did you point the gun at him and pull the trigger? I just will never understand it. Oh, I've been asking myself this over and over for months. How? Why? How could you look at his sweet face and do this? I don't know how. I'm disgusted, I'm disappointed, I'm angry, and I'm just plain sick over all of it, sick over it, every day sick over it. I have known you since we were children, and you were always nice to my kids. I just don't understand. Just absolutely no respect for Michael's precious life. I know you are sorry, but it cannot bring Michael back, and things did not have to be this way. They did not have to be this way. I don't know. I don't have any more to say.
I see that you have pictures with you.
Yeah, I have more pictures. I know I sent you some, but I have pictures, so many. I had big boards, but I didn't want to bring them with from my daughters, and I made these beautiful boards for him for the wake. So many of his friends came to the wake. It was so many people. I could give you these if you want. Some I sent, but I could still, and I have more. Did you want to see them?
I would look at any pictures you want to show me.
Okay. And I
Do you
think
want to show them just to me, or would you like the district attorney to put them up on the view screen for everyone to see?
However you want to do it. But this one I really like.
It's up to you, ma'am, what you would like.
Okay. Yeah.
On the big screen, or not just the judge to view them?
It doesn't matter. Yeah.
Do you want them in any certain order, or just
However, yeah, I just have so many pictures of him.
Do you want me to put them up, and then if you want to tell her about any of them?
Sure.
Okay.
Oh, that's okay. I think that's it. These these
Are any
ones.
of these originals?
Some on the top are, yeah.
I just don't want to take any originals.
Yeah.
Because I want to make sure you have.
Okay,
everything that's
okay, yeah, I
yours.
have so many.
Are these originals or are these?
No, I printed those out.
So everything in this stack? is
Yeah,
okay.
yeah.
Judge, she has a stack of photos. I'll put them up on the overhead. I'll have the clerk staple them as a packet, and then they can be marked as an exhibit. And
Any
then-
objection?
No objection, Your Honor.
All right, we'll have them marked as Exhibit 1. It's a packet of photos. Oh, what number will it be then? 4? Okay, so Exhibit 4 for the photos. I don't want to staple them because they'll have to be scanned. Just a paper clip. We can put the sticker on after, that's fine.
So this is the first page of the packet.
Yeah,
If there's anything you want to say about any of them,
okay.
please feel free.
That's Michael and my mom, that he went to Lake Como with his grandma. He loved her a lot. He liked to go a lot of places with her. That was 4th of July, 2024. That's his first birthday. We went for a walk.
Page 2.
Swimming, we did a lot of swimming together, Michael and I, and my other daughters.
Page 3.
Oh, that's when he was little, yeah, with his sunglasses on. Really cute. He liked sunglasses.
That was page 4.
And that's his younger sister, his playmate, Madeline.
That was page 5.
He's a very proud uncle of Cuno, who's a year old now. He was, I think, 2 months there, maybe. He just loved Cuno.
That was page 6.
He loved Christmas. That was actually September. And I snapped a picture of him. He loved Menards. He loved going shopping with me at Menards. And he wanted to dance with Santa there. Really cute, the Santa dances. And that's Cuno again, his nephew.
This is page 8. Page 9.
Madeline and Michael together getting our Christmas tree. Cuno. Yeah, he loves Cuno. That's Michael and I on the 4th of July.
That was page 11.
I love this picture out of all his birthday pictures. It just really is his personality. He's so happy.
That was page 12.
This was his first grade celebration, and they face painted. And before we washed it off, even though it's a little smudged, he just gave me that best smile. I love that picture.
That was page 13.
And these are just all of us together last Christmas.
That was page 14.
Michael is an uncle.
That was page 15.
Christmas celebrations. One year he wanted to be Santa so bad. So I love that picture. I think he was about 4 or 5, about 5. And he asked for a Santa outfit.
That was page 16.
And these are all the sports he did. Soccer, somebody took that picture from the soccer league. It was a great picture. And those are us swimming and golfing and playing baseball.
That was page 17.
Michael and I, those are his first steps on the bottom.
That was page 18.
And I love these pictures. That one I just enlarged of the one from Christmas, just such a super great smile. He loved to climb trees. That's just so him and so awesome. And then the one on the bottom of him jumping off the diving board that I got it in midair, that was a really big milestone. He wanted to be able to jump off the diving board. And I just like to think of him that way now too, like happy like that, I hope. And those are his sisters. From the day after he was born, that first middle one, and those are his sisters, and just having fun. Some are when he was really little. And these are just more fun times. That's Michael's best friend in the upper corner. That's Jackson. And a group of friends at a birthday party in the middle, and St. Patrick's Day parade, and 4th of July again on the bottom with my dad. My dad's in that one. Oh, and that's Jesse and I and the kids at a carnival up at the top. Yeah. Like even my dad said like how busy he was. I don't even think as a kid I was that busy, like always like doing things and just loved everything and couldn't get enough. It's so awesome. And I don't think I really thought about it as much until after he passed, like just how much he really did. No, I think that's it. Well, I have these, if you want to show them. Yeah. Oh, yeah, that's okay. No, that's, yeah. No.
Thank you
Thank you.
for sharing a bit of your son with us today.
Thank you.
Mr. Wiedenfeld, would anyone else like to give a statement? All right then. Mr. Wiedenfeld, it's my understanding there is no limit to your argument or recommendation today, correct?
Correct.
Your position.
The defendant has no respect for human life, and he just seems to lack that natural instinct that people have to protect children. He shot and killed 8-year-old Michael. And I just wanted to put up, this is Exhibit 1, some of those pictures that we just looked at. And I wanted to put with it Exhibit 2, because that's the firearm that the defendant used to kill Michael. He took that gun, he removed the magazine from it, then pointed it at Michael and pulled the trigger. And it sounds like he did that because he thought it would be funny to scare him. And I don't know who lacks that basic instinct to not feel comfortable, to feel uncomfortable pointing a firearm at a child. But in the defendant's mind, that was funny. That was something that was a joke. And what he did was so reckless and careless, it's made the community outraged. And I think careless is a good word to use here because really what he did demonstrates how little he cared for Michael. Michael was a great kid, liked sports, video games, had great friends, just a normal 8-year-old kid. And Michael looked up to Stephen, trusted Stephen, and so did Michael's mom and grandma. They all trusted him. The weekend of the shooting, Michael had been staying with grandma at her house. They went shopping, he bought a skateboard, they were having a good time, and Michael wanted to spend the night at the defendant's house because it would be fun. He'd get to stay up late, he'd get to play video games, he'd get to do all those things that an 8-year-old wants to do. And that's what he got to do. Around 1:51 in the morning of January 20th, Grandma calls and speaks to Michael, says, hey, it's late, you need to be getting to bed, it's early morning, stop playing the video games. And sometime between that phone call and when the defendant called Grandma, I just wanted to get the time. At 2:24 a.m., the defendant decided that it would be funny to do a few things. First, what he told law enforcement is that he got out a taser and that he was popping it at Michael, making it make that zapping noise, and that Michael was wiggling away. And I'm not saying he was doing this to be mean or cruel. I think this was something he thought was funny, to kind of scare Michael, and Michael would move away and try to get away, and he was doing it. Then the defendant said that he went and got the firearm, and that he took the magazine out, that he was under the mistaken belief that if you took that out that it couldn't fire, doesn't bother to check to see that there's a round in the chamber. And then the firearm was in his bedroom. He walks out of his bedroom where Michael is just sitting with a tablet on a couch and points the firearm at him and pulls the trigger. Michael had 2 gunshot wounds on his body as a result of that bullet. He had an entrance wound on his shoulder near the outside, and an exit wound kind of on the inside of his arm. And then he had an entrance wound near the center of his neck, and an exit wound near the back of his neck. That's consistent with Michael holding up his arm to feeling scared.
So it was one shot.
Yes. The defendant said that he had shown Michael his gun other times. He said that he would do it in a joking way, where he'd point it at the ground and tell him that he had to listen. Michael didn't die right away from the gunshot wound, and the defendant didn't call 911 right away. What the defendant told law enforcement is that after the shooting, he said, I looked at him and I seen the stress on his face, and he put his hand up and blood's coming down, and I grabbed him and said, let's go to the bathroom. And that's consistent with what was observed in the house, is he took Michael from that couch through the living room, through the dining area, and into a bathroom in the residence. And I do have just an image of that bathroom. I'm not going to put that up on the overhead, but it's marked as Exhibit 3 that I can provide the court as well.
For the record, are you also asking that I receive Exhibit 2?
Yes, please.
Any objection to the court receiving Exhibit 2?
No objection, Your Honor.
Exhibit 3?
No objection.
Both are received.
And one was part of the original packet, but I'd ask the court to receive that as well.
Received.
The defendant told law enforcement that he grabbed him and said, let's go to the bathroom. The defendant then said that toilet paper isn't the best thing to plug a hole. So I called Grandma, and she said to call 911. We know that the call to Grandma was at 2:24 a.m., and then the call to 911 was at 2:25 a.m. The defendant in the PSI and to law enforcement says that he has medical training. Despite that medical training, he moved Michael through the house, leaving blood, a trail of blood, and then apparently tried to stop the wound with toilet paper in the bathroom. The firearm that was used was located in the bathroom, so he took the firearm with him during this. It's not exactly clear why. And then he called from the bathroom the grandmother, and 911. Officers arrived at 2:28 a.m., so about 3 minutes after that call came in. At that time, Michael was still breathing. They were trying life-saving measures on him. The dispatcher, or the 911 recording, did record some faint moans at the time that call took place. But as law enforcement was trying life-saving measures on Michael, they did lose a pulse and he did stop breathing. He was carried out by officers to an ambulance and driven to the hospital. Shortly after arriving at the hospital is when he was pronounced dead. The defendant was 52 years old at the time that he shot Michael, who was 8. The defendant had a concealed carry permit. He had taken classes on how to safely handle a firearm. He knew that it was dangerous to point a firearm at somebody. He knew that he should have cleared the firearm. He knew that he never should have pointed it at a child or another person. And these were his bad choices. There was some alcohol in his system. He had shown a few signs of impairment to law enforcement. He agreed to provide a blood sample. A blood draw took place at 3:29 a.m., so that's about an hour after the shooting. And the result of that is a .02. So it's not that he was highly intoxicated and this was something that was driven by alcohol or that he just lacked any sort of ability to use good judgment. He made bad, reckless, careless choices. The defendant has a record that's described in the pre-sentence investigation report. I recognize that most of that is from the 90s and 2000. It includes DUI offenses, domestic violence, thefts. There's an unlawful use of a weapon charge in 1994 where he described that he had possessed a stun gun when he wasn't supposed to. And I point that out not because I realize that there's a time gap between those and what happened here, but he had interventions in terms of his own personal history, and he had opportunities to address his vices or his personality issues, but nothing changed. Defendant was cooperative with the investigation. He admitted to shooting the victim. He admitted it in the 911 call. He admitted it to law enforcement. And he pled guilty without having a trial. So I do think he's accepted responsibility for what he did. There's been no real efforts to minimize, other than perhaps some statements about that he didn't really think he was pointing it at Michael, just near Michael, or things like that. But for the most part, the defendant's accepted responsibility for what he did. This is a serious offense. And in terms of a reckless homicide, this is about as serious as the facts can get. This isn't a homicide where an adult chose to get in a vehicle with a drunk driver and then there was a fatal crash and that victim, although it's not their fault, they made some choices that contributed to their death. Michael was a pure, innocent 8-year-old boy who just wanted to play some video games and have fun. And this isn't a drug overdose death situation where someone was a drug user and had an addiction that contributed to their death. Again, Michael was trusting. He trusted the defendant. He wanted to be with the defendant because he thought it would be fun. The defendant knows how to use a gun properly, and he's the one who chose to use it in this reckless manner to try to scare Michael, to try to be cool. And he did that to a boy who trusted him and respected him and was following the rules that the defendant laid out for him. When I think about the seriousness, I think the fact that Michael's death wasn't instant is also an aggravating factor. When I think about these cases, I think about what Michael was thinking in those minutes before he died. He'd been betrayed by someone he trusted. He was probably scared, in pain, probably thinking that it was cold as he was laying on the bathroom floor. And someone who he was trusting to help him moved him into that bathroom and was trying to put toilet paper on the wound before calling 911 for help. The only real mitigating factor in this case is the defendant was honest about what happened and has accepted responsibility for his actions. And in evaluating the seriousness, it's hard to craft a sentence that's consistent with it. Michael had a full life ahead of him. If he lives to be 70 or 80 or older, that's more years than we even have available as a maximum sentence. And all that time, all of that life that Michael had to live, all those positive effects that he would have had on his family and the people around him, all of that was stolen by the defendant and his reckless, careless actions. And those actions didn't just harm Michael, they harmed others as well. Law enforcement and medical staff had to respond to this gruesome scene trying to revive a seriously, critically injured child. We've heard from Michael's mother and in the victim impact statements from other family members feeling guilty. They're blaming themselves just for giving the defendant access to them. But there was no way to know that he was going to do this because they have an instinct that would protect a child. They understand that it would make no sense for somebody to point a firearm at a child and pull the trigger. They have something that the defendant lacks, and they just didn't know that he lacked that ability. Michael had 8-year-old friends in school who had to learn about death at a young age, who attended a funeral, who had a counselor in their classroom to help them get through this. And that's what the defendant did when committing this crime. This is the type of crime that squeezes the happiness out of a community and leaves everyone feeling empty and sad. In terms of the defendant's character, I think the crime here fits his character. I think he's reckless, and I think he's careless. And I think he lacks that instinct to protect children. Pointing a gun at a young child is something that should make somebody's skin crawl, and just the idea of it should make them feel uncomfortable. And the defendant's doing this in a joking manner and laughing. In terms of his character, the defendant in the PSI and in his own sentencing memo talks about his history and having a bad childhood, having medical issues, having a death of a loved one in the last year before this offense. And the problem that I have with that is that somebody who goes through those experiences should come out feeling more protective of kids and should come out feeling more protective of life. And I don't think that it really explains this behavior. There's no explanation for this behavior other than just it's who he is and it's the bad choices that he made. In terms of his character, the defendant's comment to the PSI writer about what he would do if he's released is he said that he would play video games and eat good food. He doesn't talk about going back to the community to try to help people heal. He doesn't talk about trying to live a life that makes up for the loss that he's caused. He focuses on himself. And I think that's consistent with what his personality demonstrated in this offense. And that's why there is a need to protect the public from the defendant. Because how do you keep people safe from someone who just lacks that basic human instinct or emotion to protect life? I don't think this is a situation where if you take away the guns and you take away alcohol, that the problem's solved. Because this is a deeper issue than that. I don't know how you teach someone to care about others more than themselves. I also think that this is the type of case that calls for deterrence of others. Firearms are dangerous, and people know that. But it's also important for people to understand that when they are reckless and careless, and when they kill people for no reason, that there's going to be serious consequences. And that's something, regardless of where people fall on the political spectrum, whether you're pro-firearm, anti-firearm, nobody thinks that what the defendant did is right or okay, or that he should have had a firearm that day. The potential maximum sentence, as described by the court, is 45 years of initial confinement followed by 20 years of supervision. Again, I recognize that the mitigating factor here is the defendant accepting responsibility, but I think that this is still a very serious offense that warrants a very serious period of confinement. What I'm asking the court to do is sentence the defendant to 30 years of initial confinement, followed by 15 years of extended supervision. I would ask for conditions of extended supervision that include no contact with the victims or their residents without the victim or agent's consent. Restitution, if any, is claimed. Costs, DNA sample and surcharge. That he not possess any weapons or ammunition. That he not possess or consume alcohol or illegal drugs. Not possess drug paraphernalia. Not enter any bars or liquor stores. No contact with minors without agent approval. I don't think he's somebody who can be trusted with kids. I don't think he possesses that ability to protect kids. But I think that an agent can evaluate situations in the future and make those decisions. That he be ordered into counseling as recommended by the agent. And I'd ask that he not be found eligible for any type of programming. I don't believe he's statutorily eligible. Everybody here wishes that we could bring Michael back. And I'm sure everybody wishes that they could take the defendant up on the offer to trade spots. It's haunting, this idea that somebody could do this to an 8-year-old child who trusted him, and his actions require lengthy confinement and supervision. When I think about this case, I think about Michael seeing that gun and feeling that bullet And the sentence that the court crafts should try to give closure and peace to the family and the community. So I would ask that the court sentence consistent with my recommendation. Thank you.
Thank you, Mr. Wiedenfeld. Mr. Yachman.
Thank you, Your Honor. I think it's easy in this case to have an immediate reaction just by hearing the facts of the case. Lost his life. That is something I know the family has understandably and really struggled with throughout this time. That's something that I think Mr. Merkel thinks about every single day. Every time we talk, he talks about just how remorseful he is for his actions. Sometimes doesn't have the words to explain it. I think just hearing the facts of the case, it's important for the court to recall the case law we are guided by, State v. McCleary and State v. Gallion, that asked the question of what is the minimum sentence necessary in Mr. Merkel's case, consistent with the sentencing goals of protection of the public, gravity of the offense, and the rehabilitative needs of the defendant. And I know the court doesn't have an easy decision here. I don't want to reiterate the facts that have already been stated here in court and that has been stated in the complaint that Mr. Merkel stipulated to the facts, but I do want to point out a few factors here that I believe will justify my recommendation. To start off, I think this was a really close family. There's some family dynamics here in this situation. Stephen lived on the same property or near the property of Christine, who was MM's grandmother. And MM would visit Stephen from time to time. They had a relationship. They would see each other when MM would come and visit, and they shared some interests such as video games. Stephen here believed that the firearm was clear when the magazine was out. He told officers he didn't believe it was capable of firing without that magazine in there. He was under the understanding at the time that he believed that this firearm would not fire when he entered the living room. I think it's important to note how upfront Stephen was with accepting responsibility here. Immediately, he tried to give medical attention. He talked about how it wasn't maybe the most appropriate medical attention, but he did try to do something in that regard. He called the grandmother. I believe that was out of panic and not knowing what to do in that moment. And then he called 911. He was upfront with the dispatcher about what had occurred. When officers arrived, he was there telling them, this is where MM is, this is where the firearm is, so that they could focus on really what they needed to do in that moment rather than worry about him. And he can still takes responsibility to his actions from this day forth. And I think that says a lot about his character. I think it's important to note, and I think this is something Marissa brought up too, that this was not a case of ill intent, and I think that is reflected in the charges, but I think that's something important to note here, that there was, in Stephen's mind, he had no ill intent here. He mishandled the firearm. He handled the firearm inappropriately, something that, again, he's been very forward about since the beginning of this case. This is, I know, something he would never have imagined happening. He is something that he lives with every day, and when we have our talks, he talks about how he just cannot believe what had happened here. A little bit more about Stephen. I outlined it in the sentencing memo, but he has faced trauma throughout his life, losing his father at a very young age. He came to the area when his mother remarried, and he struggled with the relationship with those he trusted, facing abuse, facing trauma throughout his life. And this led Stephen to fall into the wrong crowd. He talked about how he joined a gang at a young age. This led him to having some head trauma, which had limited his ability to work, and I think that really limited his ability throughout his life to understand or process things. Not in a competency way, but just, I think Stephen thinks sometimes differently than we would normally think. And I think one of the things here is how Stephen's support system has really been diminished. He was married but separated to Melissa. They had one daughter, Marissa, who spoke today, talked about that relationship with his father, and I know Stephen wants to pass along his thank you for her coming to speak. That has been one of the biggest supports in his life ever since. Melissa's mother would assist him with transportation, with medication. He's somebody who did require some of that assistance throughout his life, and that is something that when he did have a longtime partner who recently passed away, somebody who he relied on, and I think really since that point he's been struggling to find that support system. One of the things I think the state brought up that I would like to touch on is Mr. Merkel's prior record. As the state noted, this is about 25 years old at this point. And I think this really points out how Mr. Merkel has that opportunity to be rehabilitated. We've seen evidence through that. It's been about 25 years since he's really been in any trouble. He really took what he was given at that point seriously, and he was able to, up until this point, really be able to live a normal and responsible life. Again, I just want to inform the court, I know Stephen will be making a statement, but in our conversations together, just the remorse and regret that he has for his actions here today. It is something that he talks about every time he talks about in this case. I know he's struggling getting through today's sentencing hearing, as are others, but it is something that he does really take accountability for his actions and simply does regret. When talking about an appropriate sentence, Stephen has been upfront. He talks about how he knows this is a prison case. He knows he's going to be serving prison time, and that's something he is ready and willing to accept. When we're asking for a sentence, we're asking for 11 years initial confinement and 5 years of extended supervision. We think that we agree with the state. I think one important condition of extended supervision would be these mental health assessments and counseling. That I think is going to be important for Stephen. Again, not to diminish anyone else's feelings or how they're feeling about this case, but this is somebody that, is someone that Stephen loved and he cared about as well. It's something that he's faced with this trauma. He's really been living with this every day, as I know other people are, but really with Stephen, he's been faced with this, and he is very remorseful for his actions, and that's something I can't underscore enough. I understand this proposal can again give that immediate gut reaction, but we do believe that this is the minimum sentence necessary to achieve the goals of sentencing. This proposed sentence certainly underscores a serious offense, placing Mr. Merkel in custody for over a decade. He's going to be in his 60s when he's released. He'd then be subjected to extended supervision, which would help him continue that mental health treatment that he does required, and really still keeping him accountable for another 5 years, if not longer, after his incarceration. Your Honor, again, I think I just want to reiterate just how Mr. Merkel understands that this is a tragic case, and this is the loss of a life, nonetheless someone as young as that makes it just all that more difficult. And again, it's something that from the start, Mr. Merkel has really taken responsibility for and has been really remorseful for. He's, given the circumstances here, again, he always talks how he should have done something different, how he should have checked the firearm, how he should have not even brought it out in the first place. I think with the really rehabilitative needs that Mr. Merkel requires, really just kind of helping them with that understanding, really kind of helping them what is appropriate and not appropriate. We asked the court to respectfully sentence Mr. Merkel to 11 years of initial confinement, 5 years of extended supervision. I know the PSI had asked for 18 to 22 years of initial confinement, 5 to 6 years of extended supervision. We do believe that with the factors here, along with what we had laid out in the sentencing memo, is an appropriate sentence in this case, and we would ask for that.
Thank you, Mr. Yachman. Mr. Merkel, you have the right to address the court. Is there anything you would like to say today?
Yeah, first off, I'm here to accept responsibility for my actions in this tragedy. I'd like to apologize to the court as well as to the victims affected in this tragedy.
Anything else you would like to say?
Not at this time, Your Honor.
I'm going to take a short recess to consider my sentencing. We'll be back in about 15 minutes. We're in recess. Thank you. Please be seated. Thank you for waiting. There were a few things I wanted to consider before making my remarks and sentencing the defendant here this morning. I have reviewed the file, all of the materials that are on file here. I have heard the argument and recommendation of the state and the argument and recommendation of the defense and the defendant's statement to the court as well. And I have reviewed the victim impact statements that are on file, the written ones. Also, what both Michael's mother and father spoke about to the PSI writer. And I've heard the statements today of the defendant's daughter and of Michael's mother. I've handled a number of devastating cases over my years in the criminal justice system. I think this is one of, if not the toughest one, because of the senseless and absolutely preventable death of an innocent 8-year-old boy who just wanted to hang out and have fun with an adult in his life whom he trusted. I can't imagine the pain of losing a child in any circumstances But it's pretty unimaginable the way that this has happened to Michael and his family that is left behind. This did not have to happen. It was entirely preventable. Senseless. It's something that is incredibly hard to wrap one's head around. I have heard the recommendation of the district attorney's office. The district attorney is recommending 30 years of initial confinement and 15 years of extended supervision. The Department of Corrections through the PSI is recommending 18 to 22 years of initial confinement and a period of time of extended supervision after that. The defense is recommending 11 years of initial confinement and 5 years of extended supervision. The court has to look at what are its sentencing objectives with regard to this case. First of all, protection of the community is absolutely important here, and it's a priority. No one in their right mind would ever have thought that something like this would happen by this defendant to Michael. And yet it did because of choices that he made that night. The protection of the community is incredibly important here. Punishment is an objective of the court as well. It's one of the ways that human beings learn, is through punishment. Part of a deterrent. Deterrence of others, as noted by the state, is an important objective of this court as well. That the community sees that someone who chooses to act in this way with an utter disregard for the sanctity of human life and the trust that has been placed in them by an 8-year-old boy and his family, that there are consequences for actions. The court is torn as to whether or not an objective of its sentence today is rehabilitation of the defendant. Because the court shares the state's concerns, what is there here to be rehabilitated? This was a reckless choice that no one in their right mind would have ever thought would happen. How do you rehabilitate someone from making those kinds of choices? Someone who is a full-grown adult, 52 years old when this happened, with an education, a background having been trained as an EMT, having training in surgical technology, and having been through a concealed carry class with regard to firearm safety. What more is there to be rehabilitated that weren't already in his skill set to prevent this from happening again? Or is the objective of the court rehabilitation in terms of, as kind of mentioned by the defense here, counseling to help him live with what he has done? When I look at the crime here, and make no bones about it, this was a crime. First-degree reckless homicide. This wasn't an accident. This wasn't a mistake. I'm not sure if it was in the PSI or the defense memorandum. I think it was actually in both. The defendant referring to this as an accident, a freak accident. A freak accident is something that is not preventable. That is not what this is. This was entirely preventable. This was the result of reckless choices, a series of them. The defendant told police, and I'm getting this information from the PSI, Stephen stated that he showed Michael the guns because it made him look cool. That's one of those things that it's impossible to wrap one's head around. A 52-year-old at 2 o'clock in the morning, roughly, pulling out firearms to look cool to an 8-year-old. I know that alcohol was involved, although there's no indication here that he was impaired to the point of intoxication. About an hour and a half, roughly, if my times are right, after the shooting, his blood alcohol level was a .02. He admitted to having 2 rum and coke drinks that night after Michael's grandmother left the house, so after 10 p.m. Sitting around playing video games with an 8-year-old, but you needed to drink? Maybe that's where the rehabilitative needs are. But there's no indication that you were intoxicated. The PSI goes on to state that you told police, he stated that he showed Michael a stun gun that he had at the residence and was, quote, popping it, end quote, and pointing it towards him while he was squirming away. A stun gun is still a weapon. How is that fun? The defendant then went to his bedroom, took out a 9mm handgun, and took the magazine out of the gun. He did not believe the gun would fire without the magazine in it. He reported he walked out of the bedroom, pointed the gun at Michael, and pulled the trigger, expecting it to click, but instead it went, quote, boom, end quote, shooting Michael. He stated that he was trying to be, quote, cool and exciting, end quote, for Michael. How is it cool and exciting to point a gun at an 8-year-old boy? Today's the first that the court learned that the bullet went in through Michael's upper arm or shoulder area, came out, then passed through his neck. That's a defensive posture. How is that fun and cool for Michael that you come out of a bedroom pointing a gun at him to the point where he's scared, he puts up a defensive arm, and you shoot him? How is that fun? How does that make you look cool? You were asked if you had ever taken a hunter's safety or concealed carry class, to which you said yes. When asked if you had ever pulled a weapon on anyone before in a joking manner, you said, quote, I might have done, strike that, quote, I might have before with Michael, but that would be with, you know, the gun I usually carry concealed, end quote. You then mimicked how you would do it before with Michael, with police. You mimicked drawing a pistol and pointing it toward the ground. You said you would do this to get them to listen fast. And when asked by officers if you thought that was a good idea, you said probably not. You told the PSI writer And this is different than what you told police. You told the PSI writer, you asked Michael if he wanted to see the gun and learn more safety. One of the first things that's taught with gun safety is you never, ever point it at someone. You never goof around with guns. Yet you tell the PSI writer you wanted to show Michael gun safety. That's not what you did. Mikey said yes to wanting to know more about gun safety. So you unlocked your safe with the firearm. You removed the clip from the gun and went to show Mikey the gun. The gun fired, and you lowered the gun and saw a hole in Mikey's neck. And you admitted in your independent memorandum to the court that you pointed it at him and pulled the trigger. When they searched your residence, they found 268 rounds of ammunition in various sizes and brands. You had inside your home a shotgun, a full-sized 9mm handgun, and a Smith & Wesson handgun. Apparently, you also had that stun gun in the house. There are three primary sentencing factors that the court is to consider when weighing an appropriate sentence: the need to protect the public, the gravity of your offense, and your character and rehabilitative needs. Clearly, through the court's recitation of what happened that night, this is a serious offense. They don't get more serious, other than if this had been intentional, and there's no indication that it was. Not at all. It was reckless, but it was based on choices that you made. Again, the protection of the public is a paramount consideration of the court, and your character and rehabilitative needs. In weighing these factors, the court looks at a number of considerations. Your prior record. The prior record is listed in the PSI. It's been touched on by the state. Although you haven't had any criminal convictions in roughly 20+ years, you do have priors before that. Everything from thefts to OWIs, domestic battery. There's that unlawful use of a weapon charge from 1994, which is concerning to the court. You've been on supervision before. I am to consider if you have a history of undesirable behavior. In the PSI, it talks a bit about your history of a variety of different type of drug use. Apparently, it's been several years since you have used controlled substances. I am concerned there might be an alcohol problem here based on the DWIs in your past and the fact, as I've already said, that you were drinking this night, although not to the point of intoxication. I am to consider your personality, character, and social traits. I know that you have some mental health diagnoses for which you have received treatment in the past. I know that you had what seems to have been a difficult childhood. From the age of 17 until she passed, your age 17 until she passed, you did not have a relationship with your mother. Your biological father died when you were very young. There are contradictory indicators from the PSI versus the defense's sentencing memorandum with regard to your relationship with your stepfather. But it seems that you did have a difficult childhood. At one point, you were in a gang. Because of your involvement in that gang, you were attacked, you were almost killed, you suffered a TBI. That was at the age of 14. However, you still, although you dropped out of high school, you got your GED, you took college classes, including a certification as an EMT. You got a certification in a surgical technology program. You've had numerous short-term jobs over the course of your life. You currently are on disability. You married Michael's mother in 1995 and apparently were never divorced, although you separated and have been separated for a number of years. Michael's mother had Michael and her other daughter with Michael's father. You have one child with Michael's mother, and she spoke here today. And the court's heart, of course, goes out to her, the incredibly difficult situation that she is in here today. And I want to be clear. The court does not think that the defendant here is a monster. I certainly have seen persons come through criminal court who I would describe as evil to the core. That is not you, Mr. Merkel. I believe that you are remorseful. I believe that you would trade places with Michael if you could. You are here because of the unbelievable choices that you made that night. And the court looks at you as an entire person in deciding what's the appropriate sentence here today. I know that your daughter is your sole child. She has 2 young children who are your grandchildren that you are close to. I know that you had a long-term girlfriend who passed away recently before this happened. According to the PSI, you have friends and seemed satisfied with your life. I am to consider if this is a vicious or aggravated crime. The court considers this to be aggravated. Showing off to look cool by getting out a gun and pointing it at an 8-year-old and pulling the trigger when this was not the first time you were messing around with guns in front of him. Aggravated, especially when you are in a position of trust over this boy. His mother, his grandmother trusted that you would take care of him. Instead, the absolute insanity of your choices that night, it's appropriately charged. Recklessly knowing the danger and showing utter disregard for human life, you made the choice to do that, to look cool. Your degree of culpability is 100%, and to your credit, you told the police what happened. As I've already stated, there's been some variations in terms of what you were actually doing that night. Were you showing Michael how to safely handle a gun, or were you just trying to look cool? But regardless, you did call 911. You did confess, and you pled guilty as charged, recognizing what you did and sparing the family of a trial. I recognize that. Your demeanor in court has always been good. You are now 53 years old. I've noted your educational background, your employment history here, and what I believe to be a sincere statement of remorse. Although calling it an accident, as I've already stated, I disagree with. Your need for close rehabilitative control is incredibly high. Again, because who would have ever guessed that you would make a choice like this? But you did. And that means the community is at risk, because what kinds of other choices could you make? The rights of the public here, as I've already said, are paramount: to be safe from your reckless behavior and your disregard of the incredible risk involved with guns. This was real life. This was not a video game. You have been detained since you shot Michael. I've already noted the aggravating factors here. The mitigating factor is, again, that you confessed and you have pled guilty. Obviously, this is not a probation case. Absolutely, confinement is needed to protect the public, and probation would unduly depreciate the seriousness of the offense. When I weigh the three sentencing factors, consider the court's objectives, and all of the considerations here today, I am sentencing you as follows: 25 years of initial confinement, followed by 10 years of extended supervision. I absolutely think that this is the minimum amount of confinement and custody consistent with the sentencing factors as I have weighed them here today. I am adopting the recommendations for extended supervision as stated by the district attorney. He is not statutorily eligible for the challenge incarceration program, nor for the earned release or substance abuse program. It was evident to the court today, listening to Michael's mother talk about what a wonderful young boy he was. I sincerely hope that your memories, the family's memories of who he was and the time that you did have with him, are a comfort to you. Mr. Yachman, will you go through the defendant's post-conviction rights with him?
Yes, Your Honor.
Mr. Wiedenfeld, were there any other findings or orders that you believe I need to address that I did not?
No.
Mr. Yachman, same question.
Your Honor, in regards to the credit, I don't know if that'd be as part of probation or if that'd be applied to his initial confinement.
Correct, it will go toward credit. So he's been confined since January 20th. Madam Clerk, did we count that to be 303 days? I would ask both the state and the defense to check the math, but I believe it's 303 days of credit.
That's my number as well.
Thank you, everyone. We're adjourned.